page 51, paragraph 181, he says, "For this reason, the EFF seeks an order from this court declaring that decision unlawful and setting the resolution aside." So it's a review. We all know the consequence of that. It may not be unreasonably delayed. And we make the submission that the EFF has disabled the court from deciding the application because there has been a patently unreasonable delay. There has been no attempt to explain the delay, and there has been no attempt to produce facts which show why the delay should be overlooked. Then on exclusive jurisdiction, the core complaint of the EFF is that the decision of the Assembly was irrational. Rationality is an obligation which rests on all who exercise public power. It's not an obligation which is specific to the National Assembly. The analogy is this: if the President takes administrative action and he breaches Paja, that doesn't bring it within the exclusive jurisdiction of the court, because the obligation to take lawful administrative action rests on all administrators. It's not an obligation that is specific to the President. Similarly, a challenge based on alleged irrationality doesn't trigger the exclusive jurisdiction of this court. The EFF does attempt to show that the application rests on a failure of the NA to hold the executive accountable, and that is a specific obligation of the National Assembly. But we say that the National Assembly has held the President to account. Firstly, the Speaker considered the motion, found it compliant with the rule, and referred it to an independent panel. The Assembly, through the Speaker, established an independent panel to investigate the matter. The panel conducted an investigation. The President was required to explain and justify his conduct in what became a public forum, effectively. The panel recommended that a Section 89(1) impeachment inquiry be proceeded with, and the National Assembly considered the recommendation and didn't accept it. So the procedures to give effect to Section 89 of the Constitution were operationalized, and the President was called to account. The EFF's complaint, real complaint, is that it doesn't like the result or the outcome of the process. It doesn't say the process wasn't followed. It says we don't like the outcome of the project, of the process, because the majority of the NA, by means of a vote, made a decision which it did not like. We say that, make the submission that that's not a failure to hold the President to account. We refer to what Chief Justice Zondo said in EFF 2, that paragraph 93, where he said, "Whether the National Assembly has held the President to account through a motion of no confidence in him or not cannot depend upon the result of the vote. You've held him accountable or you haven't held him accountable." The process was followed. The NA did hold the President to account in accordance with the rules. As to the exclusive jurisdiction of the court, we submit that the complaint of irrationality doesn't trigger the exclusive jurisdiction, and if the complaint of a failure to hold the President to account could trigger the exclusive jurisdiction, as a matter of fact and as a matter of law, the National Assembly did hold the President to account in accordance with the rules and the process designed for that purpose. That brings me then to the fundamental error committed by the panel. We submit that the rules create a multi-phase decision-making process. At each phase, there's a distinct question to be decided by a different decision-maker. Phase 1, the Speaker. The question the Speaker must answer is the motion compliant with the criteria set out in Rule 129A? Does it prima facie show that the President did the impeachable conduct? That requires some consideration of credibility. It's not just enough to say, is it acceptable? Because, for example, if the complaint says the President, if a political opponent of the President died recently, and a complaint is laid that the President murdered his opponent, that would be an impeachable offense. But you've got to go further and produce some evidence to show prima facie there's something behind it. There must be something that will pass muster. That's the first phase. Second phase, the panel must conduct an inquiry. It invites further information from members, gives the President RD, and it must answer its question. It must recommend whether sufficient evidence exists to show that the President committed the conduct. Then the third decision maker is the NA. It must decide whether to approve the recommendation and send the matter to the impeachment committee. The matters the NA must consider are not specified in the rule, and its questions will be whether it is persuaded by the panel's recommendation, and if so, whether it considers that the impeachment process should be initiated. It's a large and far-reaching decision. It involves more than rubber stamping what the panel has recommended, even if the panel's report is flawless. The fourth decision maker is the impeachment committee. It must conduct an inquiry to establish the veracity of the complaint, and if veracity is established, the seriousness of the charges. So there we are now into veracity and seriousness, and must make a recommendation to the NA. And the final decision maker, of course, is the NA. Its question is, should the President be impeached? And so each time there's a different decision maker with a different decision. And the mistake that the panel made was to consider that it had to answer the same question as the Speaker. The panel did this despite the fact that the question the rules require it to answer is different from the question that the Speaker has to answer. The Speaker must answer whether the motion and the evidence, not just the motion and the evidence, prima facie show that the President committed the impeachable conduct, and the panel must consider whether there's sufficient evidence that the President committed the conduct. And the obvious questions are these two questions. Firstly, why would the rules require two different actors to answer exactly the same question? What would the purpose be of that? Secondly, if Parliament did intend to require that these two bodies should answer the same question, then why did it use different language for each of them? It's a basic rule of interpretation that the use of different words demonstrates a different intention. It's got nothing to do with the situation referred to by Mr. Katz, where you have different countries having different standards for criteria for extradition, and a court has to decide whether they're equivalent. This is the use of different words in the same statutory instrument, the rules. And it's right that a court will hold that this difference signifies a different intention. And so we submit that the panel ignored the careful step-by-step process and ignored the fact that the rules require different actors to answer different questions. The sufficient evidence test, the prima facie test, is a screening or filtering mechanism, prima facie impeachable conduct. In contrast, sufficient evidence is materially weightier because now you've got more evidence in front of you, and because it's the trigger for a possible impeachment inquiry. And we say, with due respect to the panel, that it asked itself the wrong question, and you don't get the right answer if you ask the wrong question. Certainly, we submit the Assembly was fully entitled to take the view that for this reason, amongst others, it would not approve the recommendation of the panel. There was nothing irrational or impermissible about that decision. The NA was performing its function as the third decision maker in a multi-stage process. And that brings me to a core submission which I need to emphasize. Ultimately, the question before this court is with respect, not whether the panel's recommendation was right or wrong. This is not a review of the panel's decision. The question is whether it was lawful for the Assembly, after a debate and a vote, to decide not to approve the panel's recommendation and not to send the matter to the impeachment committee. Incidentally, in the end, the Assembly didn't strike down the report of the panel. It declined to follow the panel's recommendations. And the EFF has failed to show what was unlawful about this decision of the committee, of the Assembly. Then the question of evidence. The panel was required to consider whether sufficient evidence exists. Sufficient enough evidence, actual evidence exists is in existence, not might be found if you conduct a further inquiry. The panel went beyond the evidence. It received and considered and reached conclusions based on, amongst other things, suggestions made, for example, by Mr. Fraser, allegations made by Mr. Fraser where he produced no evidence to support them, speculation and suspicions as to what the position might or might not be, statements by Mr. Fraser as to where there might be other evidence, and hearsay evidence which the panel considered without applying the well-known tests for when the rule against hearsay evidence may be deviated from. The panel relied on all of this material in reaching its conclusions. Again, the question before this court, we submit, is not whether the conclusions which the panel reached could be justified. The question is a fundamentally different one. It is, was the Assembly entitled to decide not to approve the panel's recommendation for this and for other reasons? The NA exercised its power as the third decision maker to decide not to refer the matter to the impeachment committee. We submit it was entitled to make that decision, and there was nothing unlawful about the decision. Then fourthly, bad faith. The prohibited conduct requires dolus. It is deliberate conduct by the president himself in bad faith. Again, in this context, we submit it's important to get the question right. The question is not whether the president acted correctly in all respects. It is whether, if he got it wrong in some respects, this is shown to have been deliberate and in bad faith. And that is most simply demonstrated by the debate in the report about the correct interpretation of paid work. The panel analyzed the question and it came to a conclusion about what the correct interpretation is. But even if one assumes for the sake of argument that its interpretation is the correct one, that doesn't answer the question whether the president deliberately and in bad faith adopted a wrong interpretation of the term paid work. The president's farming activities have never been a secret. He's published a book of photographs of the particular breed of cattle in which he has an particular interest. It seems very unlikely that he deliberately and in bad faith ignored the law and then publicized his activities. Perhaps more likely is that he genuinely thought that he was entitled to act as he did, and he lacked dolus and bad faith. Again, the question is not whether the president's interpretation was right or wrong, it is whether his interpretation was in bad faith. And again, the critical question is whether the Assembly was entitled after debate to decide for this reason, amongst others, that the matter should not be sent to the impeachment committee. That brings me finally to the reasons Minister Lamola gave for opposing approval of the panel's recommendation. And the EFF asserts over and over again that in assessing the rationality of the NA decision, one can have reference only to what Minister Lamola said in his speech. The first thing I note is that the EFF has caricatured what Minister Lamola said. What he actually said is summarized in the ANC's answering affidavit, supplementary volume 3, pages 862 to 868, paragraphs 68 to 70. Volume 3, pages 862 to 868, paragraphs 68 to 70. But the EFF, with respect, gets the point wrong. The test for rationality is objective, not subjective. It's not whether an individual, Minister Lamola, subjectively asserts a rational connection. It's whether objectively there was a rational connection between what was done and the power. And in the Mortal case, Justice Kampepe said this on behalf of this court at paragraph 69. She said, "The principle of rationality requires that every exercise of public power, including every executive act, be rational. For the exercise of public power to meet the standard, it must be rationally related to the purpose for which the power was given. It is also well established that the test for rationality is objective and distinct from reasonableness," close quote. So the question is whether there is an objectively rational basis for the decision, not what the subjective view was of a particular decision maker, 1 out of 400, Minister Lamola. In any In this case, 214 members of parliament voted against accepting the recommendation of the panel. One could never apply a subjective test to 214 people, find out what the subjective intention and reason was of each one of those. Each of them would have had their own subjective reasons and their own subjective views about the reasons for the decision. The speech of Minister Lamola was not an affidavit subscribed to by 214 members of parliament, each of them saying, these are my reasons and these are my only reasons. And so the attempt by the EFF to straitjacket the defence to this application into one part of what Minister Lamola said is simply wrong in law and wrong in logic. I need to make a key underlying proposition to all of this, which I wouldn't like to be lost, and that is when the National Assembly makes its decision, it has a residual discretion. This is addressed in our heads of argument in paragraph 61 to 62. The sorts of matters that the NA may consider in the exercise of its discretion are set out in paragraph 61. So then I do have time, to my surprise, to respond to what Mr. Katz said. I'm not going to respond to it in detail, to the new, which is actually a new case, which is attempted to make out in oral argument, and which it seems he's still trying to work out. I will make only one observation. His submissions with regard to the assemblies, his submissions deal with the National Assembly's carrying out of its functions, deal with them as if they were administrative action. For example, if political considerations enter their decision-making, the decision is invalid. Or for another example, if there are a number of possible reasons for the National Assembly's decision, one bad reason will invalidate the decision. Those are administrative law doctrines. This was not an administrative decision. This is not administrative action. It's also not executive or legislative action. This is the exercise of a sui generis constitutional power. It's a power conferred by the Constitution, which is neither administrative, nor executive, nor legislative. And you can't just import administrative law doctrines into this decision and say, because you've breached a rule in Paja, you failed to have regard to relevant considerations. You've made a bad decision. You've had a bad decision mixed up, bad reason mixed up with the good ones. Political considerations have affected you. We say this is administrative action, and it's not administrative action. It is a sui generis power, constitutional power. And then I need to deal briefly with this bogey that is raised of politicians making the decisions. The National Assembly consists of politicians, only politicians. The Constitution says that the politicians, these politicians, must decide on impeachment. The Constitution makers knew, as we all know, that they were conferring this power on politicians, not on judges or courts. They knew, as we all know, that when politicians make decisions, inevitably political considerations do weigh on those decisions. They are normal human beings. Political considerations weigh on decisions like impeachment, certainly, just like they weigh on a number of other things that they have to do. And they know that inevitably, we see it all over the world, impeachment has a political dimension. And that is why it is appropriate for the National Assembly and not the courts to decide whether the president should be impeached. And that is why the constitution makers made that choice. They conferred the power on the National Assembly, a body composed of politicians. Now, there's a fine line to be drawn here. On the one hand, we know, and this court has told us, that if the politicians simply act on the dictates of their party leaders without applying their minds to their constitutional obligations, then they're not acting lawfully. We know if it can be shown that all that is happening is they're saying, what does the party say? Well, that's what I have to do, full stop. We know that that would be impermissible. But we also know at the other end of the spectrum that it is impossible when you're deciding on impeachment and when politicians are deciding on impeachment for political considerations not to carry some weight. And the power is conferred by the Constitution on the politicians. Now, where that dividing line comes is a very difficult one to find. And it does come, one's assisted with it, Justice Tomei, if there's some criteria, I accept that. But the criteria are terribly difficult to define because you're at high risk, and the court is with respect at high risk of being overly prescriptive and then prescribing doing things which are really the job of the Assembly under the Constitution, but on the other hand being so vague that no one knows what's intended and how to do it. And it's with respect, a very difficult question as to how one would draw that line. But we do say this, that if criteria are to be determined, they have to be broad, and we say that it would be wrong to prescribe that political considerations are irrelevant. It would be unrealistic, and it would be wrong, and it would be inconsistent with what the Constitution does, which is give the power to politicians. If the Constitution makers had wanted this to be a decision made on cold legal facts and cold legal decision making, it would have given the decision to the judges. But it didn't do that because impeachment is not just a legal process, it is also a political process, and there's no getting away from it, and we have to be realistic about that. And so the question was asked of our learned friend, Mr. Breitenbach. Well, let me put it this way. So what does the Assembly have to do when it considers the report of the panel? We say the question will be whether it's persuaded by the panel's recommendation. If so, whether it considers that impeachment process should be initiated. It's more than rubber stamping what the panel has recommended, even if the panel's recommendations and report are brilliant and unimpeachable and impeccable. Because if it was rubber stamping, then there would be no point in requiring a decision by the National Assembly. You could just give that power to the panel. But that would be inconsistent with what the Constitution requires. The Constitution requires the Assembly to decide whether there is impeachable conduct, or whether there should be an inquiry into impeachable conduct. And so, for example, let me give a simple example of this. Let's assume that the panel finds that the President's committed conduct which is impeachable. The Assembly may take the view that even though sufficient evidence has been found of that conduct, the conduct is not so serious that it should result in impeachment. And that's not a legal question, that's a political question. The finding is made by the panel that the President has behaved improperly in some fashion. That's a matter on which lawyers, using well-known techniques, can decide and decide well. The question whether that misconduct, if proved, should result in impeachment is not a matter on which three very learned lawyers sitting in a panel have either the knowledge or the skills or the training to decide. It's a political question. And that's why the power to make the decision about impeachment is given to the politicians. And we say that so even at the first stage, even when the National Assembly reviews the panel report, one of the things it may say is we see the President has behaved very badly, and we see that it's been shown. But for this, impeachment is such a serious consequence for the nation as a whole that this is not the sort of conduct that justifies impeachment. That's a judgment you have to make, and I make the submission that there is no basis for saying that that's something which is solely in the hands of the panel. It is a decision which is not purely a legal question, it is a policy or political decision. And that's why the power is given to the Assembly to decide impeachment. And that's why, as this court has held, it's the Assembly that must decide whether the matter should proceed to an impeachment committee. Because that, having an impeachment committee putting the president on trial is a far-reaching action with unpredictable consequences. And the politicians must take responsibility for those consequences. They must make a decision and they must take responsibility. And so for all those reasons, we respectfully submit that the application, the challenge to the decision of the National Assembly must fail. It is too late. It doesn't trigger the exclusive jurisdiction of the court. It's based on a fundamental error committed by the panel. It would be. It's based on evidence which is not evidence. It's based on allegations, bad faith, etc. And we submit that the application, insofar as it deals with the decision of the National Assembly, should be dismissed. Can I just say one more thing about delay? The question strikes one, obviously. The decision was made in December of the National Assembly, was in December 2022. The review application was brought in February 2024. What happened? What happened, we know, is that an election was about to happen. And this was part of the EFF strategy. It's a legitimate strategy, and to advance its political cause. That's why there's such a delay, and that's why the application was brought when it was. It was brought not because of the December decision, it was brought because an election was about to happen, and this was an opportunity to make hay. Chief Justice, those are my submissions.
Thank you, Mr. Butler.
Mr. Butler, let us assume that the panel refers to prima facie or prima facie evidence, but in its definition of that concept, it defines it exactly as you would define sufficient evidence. As a matter of principle, would you have any problems with that?
No, we would have problems, Justice Madlanga, because in the context of this rule, prima facie and sufficient evidence plainly have a different meaning. And so the moment you say they're the same, you're setting off on the wrong footing. And so if you want to read the rule in its context, those phrases, those terms in their context, we say it's clear that they have a different meaning. And so it can't be done to say, well, I think they're the same. If you say, I think they're the same, and I deal with them as if they're the same, then you make an error.
I'm not just saying the panel would merely be saying they are the same. I'm going further and saying, in their definition of prima facie evidence, they go on to define it exactly the same way as you would define sufficient evidence. If you still have a problem with that, would that not be engaging in form over substance?
If the test they applied was sufficient evidence, properly understood, properly interpreted in the context of this rule, then there could be, I wouldn't have that complaint. But I would have a complaint, the complaint I have is that they say these two are the same. And the test applied by the speaker and the test applied by the panel are the same, and we say that can't be so.
Let us look at paragraph 75 at page 90 of volume 1, where the panel says this. In the
Page
con-
nine, sorry, what?
90.
90.
9 tie, as they would say at the bar, which I never understood.
I think that's what you do when you're throwing darts, yes. Page 90.
Yes. There, the following appears: in the context of the scheme for the removal of the president from office, we therefore construe the phrase "whether sufficient evidence exists" to mean whether, based on the information received, the president has a case to answer. What problem do you have with that part of the formulation?
The problem is the next sentence. Put differently, we construe the phrase to require the panel to determine whether there's a prima facie case against the president. That's not correct. That's not what the phrase requires the panel to do. It requires a weightier decision because we've had a prima facie case. Now the other members of parliament have been invited to put in evidence. The president has been invited to respond. There's a high-level panel required. It's given a month to try and do the job. It's a higher range activity than what the speaker is doing.
I'm sure you would agree, though, that what the panel says should be read cumulatively. Not so. Everything that it says in this context should be read cumulatively. Of course, it's something else altogether. Whether you will then agree that even if read cumulatively, their reading of the rule is correct. But you agree that it should be read cumulatively nonetheless.
I'm not sure, Justice Madlanga.
Okay, let me just continue. Let me leave out the theoretical question, as it were. Let's go to 76, same page. We think the purpose in interposing the panel in the scheme of the impeachment process and entrusting it with the power to conduct a preliminary inquiry into the motion was intended to ensure that the president is not required to undergo a full-scale Section 89 impeachment inquiry in circumstances where the president has no case to answer. That step must never be taken lightly. It is a momentous act, justified, and I emphasize what follows, only when sufficient evidence, your preferred phrasing, of course it's in the rule, not just yours,
Yes.
only when sufficient evidence exists to show that the president has a case to answer for his conduct, and I stop my emphasis. The panel, therefore, functions as a filter to ensure that only a motion which establishes prima facie that the president has a case to answer is considered by the impeachment committee. Why does a cumulative reading of all that the panel says, why does this not satisfy what the rule provides for?
Well, the test in the rule is whether sufficient evidence exists to show that the president committed impeachable conduct. That's the test. Not that he has a case to answer. Sufficient evidence exists to show that the president committed a serious violation of the constitutional law, etc., etc.
The case to answer relates exactly to what you refer to.
Well,
that is the itemized bases for impeachment, serious misconduct, and the other two. That's the case to meet, is it not?
Well, Justice Madlanga, the difficulty is that with due respect to the panel, it mixes the two concepts up, which are quite distinct. Read the last sentence of paragraph 76. The conduct functions as a filter to ensure that only a motion which establishes prima facie that the president has a case to answer is considered by the impeachment committee. 75, the panel to determine whether there's a prima facie case. We say that a prima facie case is something less than sufficient evidence to prove. Something less than that.
Let me move on to something else altogether. The question of the actual nature of the evidence.
Yes.
That is where your client complains, amongst others, about hearsay evidence and other forms of evidence that would, as I understand the argument, ordinarily not be acceptable in a court of law. As a matter of principle, must evidence that is admissible in a panel of this nature be the sort of evidence that is admissible in court and nothing less?
No, I wouldn't go that far. For example, if there was a signed statement, not on oath, the panel could surely have regard to it. If there was a document which on the face of it appeared to be genuine, the panel could surely have regard to it, even though there wasn't yet a chain of possession shown. So I don't submit that the panel is sitting as a court. It's not submitting as a court, and it's not applying the court's criteria, but it is having regard to evidence, and the evidence is broader than in the affidavit or sworn testimony, but it is narrower than suggestions were made by Mr. Fraser that what really happened was the following. With due respect to the panel, they had no business considering suggestions by Mr. Fraser as to what happened when Mr. Fraser had no knowledge and didn't claim any knowledge of what had happened. No, the panel had regard to allegations made by Mr. Fraser when he produced no evidence to support them and didn't say there was a witness who would support them and this is who the person was. The panel, with due respect, had no business having regard to those sorts of things. It went beyond, and it went beyond the extended notion of evidence, which I say was permissible, Justice Madlaga.
Would you say the type of evidence admissible in, for example, commissions of inquiry would be the sort of evidence admissible before the panel, or
Justice
not?
Madlaga, I don't like thinking about commissions of inquiry. Once bitten, twice shy. But yes, that sort of thing.
Would be admissible.
I would think so. I mean, I wouldn't like to tie myself to that precise definition because the courts have sometimes gone very far. The commissions of inquiry have regard to hearsay evidence very cheerfully.
Yes,
That
was exactly my next point.
I don't think a panel deciding whether there's evidence,
Yes,
sufficient evidence, can permissibly have regard to hearsay. I submit they could.
I will make the point regardless. With regard to the nature of evidence in commissions of inquiry, this is what Jafta AJP, who later became our colleague here, said in the matter of Bongoza, Bongoza.
I seem to remember counsel quoting that case.
I'm very sorry. In that matter, here's what Justice Jafta says, relying on a submission by counsel, and this is paragraph 17 of the judgment, where it says it was entitled to adopt its own procedure, that is a commission, including the receipt of evidence or information relevant to the issues before it. In fact, he contended further that the commission was responsible for collecting evidence and obtaining statements from witnesses. It could consider information of any nature, including hearsay evidence, newspaper reports, or submissions made without sworn evidence. For these submissions, counsel relied on Bell versus Van Rensbeck, S versus Mulder, S versus Sparks, and so on.
Yes.
And then in the paragraph that follows, Jafta AJP, having accepted the submissions, goes on to further strengthen the point himself.
Yes.
Why would that not apply to a panel of this nature?
I submit that the term sufficient evidence needs to be interpreted in the light of the context of the rule and what the rule is doing. The rule is about a possible impeachment trial of the president. And it's not like a commission philosophizing about its theory of the world. Some of them do that as well. It's a panel which established effectively under the Constitution to consider the most serious matter, or a most serious matter. And I submit that the bar is set fairly high. It doesn't go so far as saying evidence admissible in a court. And a newspaper report, for example, something has been reported, you may be able to rely on it, I don't know. But whereas it seems from the authorities that a commission has pretty well carte blanche as far as hearsay is concerned, I submit that wouldn't apply to a panel.
So the panel is somewhere in between.
Somewhere in between.
The court is up there, then panel, and then commission way below.
Precisely so, Justice Madlaga.
Thank you very much, Mr. Padlender.
Mr. Padlender, just on exclusive jurisdiction, you have submitted that we don't have that jurisdiction.
I beg your pardon?
You have submitted that we don't have exclusive jurisdiction. Yes. And it is because you are saying that what the EF case boils down to is that it doesn't like the decision that was taken by the National Assembly. And my question then is whether we should look, when we determine the jurisdiction, whether we have exclusive jurisdiction or not, we should look at the pleadings of the EFF.
Yes.
And if we look at the pleadings of the EFF, I'm referring you to 14.2, page 10 of the founding affidavit.
Yes.
14.2 says that, in essence, the National Assembly has failed to properly consider the content of the report. So they are not saying that they are not happy with the outcome. They are saying that the National Assembly failed to properly consider the content of the report. If you can comment on that and say why the fact that they've made that allegation does not clothe us with jurisdiction.
Justice Chiki, I read that phrase as being a sort of administrative law ground, failure to have regard to relevant considerations, failed to properly consider the content of the report by effectively setting aside the panel's conclusions without establishing a factual or legal basis upon which to do so. That reads to me like a review challenge, that you made a decision without a legal or factual basis to do so. But I do accept that if the complaint is that you failed to hold the president to account, that triggers the exclusive jurisdiction, because it is the specific obligation of the Assembly to hold the president to account. We say that they did in fact hold him to account, but that's another question. But I don't, with respect, read this as making an allegation which falls within the exclusive jurisdiction of the court. It's not the exclusive jurisdiction of the court to decide whether bodies failed to do something without establishing a factual or legal basis upon which to do so. That doesn't fall within the exclusive jurisdiction of the court. Every day, cases are brought in the High Court in which the applicant's complaint is that the respondent failed properly to consider a report, didn't have a factual or legal basis on which to do what it did. That doesn't trigger the exclusive jurisdiction of the court. And if the complaint is that a president failed to properly consider a matter and didn't establish a factual or legal basis, that wouldn't trigger the exclusive jurisdiction of the court. It's only when the matter relates to a function which is specifically allocated to that decision maker, the Assembly or the President. That's what the jurisdiction of the court says, as I understand it.
I'm asking this question because we know that that report, which the EFF alleges was not considered by the National Assembly, dealt with the impeachment of the president. And this is why I then, struggle with finding that. And on your submission, this does not revolve around the issue of the president.
If it was formulated like this, then it might trigger the exclusive jurisdiction. If the complaint was that the National Assembly did not hold the president to account because it failed to properly consider the content of the report, then that might trigger the exclusive jurisdiction. This is more narrowly and described. If the complaint must relate to a specific constitutional obligation of the Assembly, then this is not a specific constitutional obligation of the Assembly.
Perhaps then it's because I'm looking at it holistically, because I'm looking at the fact that the real complaint is that as a result of them not considering the report, they failed to hold the president into account.
Yes.
And this is why I then thought that then we have exclusive jurisdiction, because the real complaint is that had you considered the report, you would have held the president.
Yes, I understand that, Justice Chiki. I understand with respect to the point that you're making. And if it is formulated that way, then it may trigger the exclusive jurisdiction. But as you say, we have to have regard to the pleadings as they stand, and the pleadings as they stand don't make that case. They make a different case, which is that the Assembly failed to hold the president to account. They make that elsewhere in their founding affidavit. That triggers your jurisdiction. But the fact that the allegation that the National Assembly didn't properly consider the matter before it doesn't trigger, I submit, the exclusive jurisdiction of this court.
Mr. Butler, we've heard wide and varied submissions, quite critical of the panel, both during oral argument this morning, and one can find much more evidence of that in your client's affidavit. And most of it, there's a basis for it. But it seems to me that looking into the future, it might always be quite easy to impugn a report of an independent panel for reasons not associated with the expertise of the panel, their diligence, or their industry, simply because of the convoluted manner in which the rules have been devised. So what the rule says is that the panel must conclude that there's sufficient evidence to show that the president has committed a serious misconduct, a serious violation of the law, etc. But then, having charged the panel with producing a report that contains sufficient evidence, it then restricts the panel considerably, because what the panel will receive only is information. Only information from members. It may not conduct an oral hearing, and it's limited to the written and recorded information placed before it. So it can't undertake what is criticized for not doing, which is the proper evaluation of this information and to convert that information to evidence. Because ultimately, it cannot rely only on information. That information has to be elevated to evidence. And that would require some verification of that information. And so one almost senses the anguish of the panel. If you look at paragraph 94
Yes.
in volume 2, and that's at page 98. And while the panel is referring to Mr. Fraser's statements, I think they may well be a reflection of its general frustration. It says, while Mr. Fraser's statements provide information that may help to verify the truthfulness or otherwise of his allegations, the present process does not permit the panel to investigate these matters. So it has this information, but it may not investigate them. This, of course, does not mean that we must blindly accept the information contained in Mr. Fraser's statements in the hope that it may and probably will be verified. Nor does it mean these allegations must be ignored. So it sets up the two positions that it finds itself in. And then finally, it says fairness dictates otherwise. But sadly, that otherwise is not to be found in the report. And so this may be a reflection of a structural difficulty.
Yes.
That panel bring us evidence,
Yes.
but you're confined to information. And the panel tries to grapple with this at 94, but doesn't seem to provide an answer to it, except to suggest that the answer lies somewhere else.
Yes. So
Would you agree that that's
I
a
do
systemic
agree with
issue?
that. I do respectfully agree with that approach, Justice Colopin. It seems to me the panel is given a difficult job because it's required to make findings about sufficient evidence when it's not really given all the tools which are necessary to find sufficient evidence. And then it has a finding which can have far-reaching and cataclysmic consequences. And so it's the panel's job is a very difficult one. And when we criticize it, we do it recognizing that, but the criticisms really don't go to the question of whether the panel did the best it could under the circumstances. That's not the issue, or even whether what the panel found was right or was wrong. The question is whether the Assembly, when it decided not to accept the recommendation and said, well, I see all these problems in this report, was entitled to do so. And we say it was entitled to do so. It was not for the Assembly to say, well, the panel's job was a very difficult one, so I will overlook the many criticisms you could make of its report. That's not what the Assembly was required to do. The Assembly is making a decision about whether the President will go on trial. And it has to say to itself, is there a basis for that, a sufficient basis for that? And it's not, and the question is not whether the panel was right in what it said, and not even whether the Assembly was right in the decision it made. It's whether it was a decision that the Assembly was entitled to make. It had to exercise a judgment, a discretion. Did the decision it make fall within the reasonable range of what an Assembly could do? And we say yes, because there were these criticisms. Not a question of blame and pointing fingers. It's just there's a reality. The panel has to deal with the reality that the structure's awkward. The Assembly has to deal with the reality that there are problems with the report as a consequence. And it's entitled to say, well, I'm afraid this is not enough.
I accept that, Mr. Butler, and perhaps even in the context of this case,
Yes.
that may well be an outcome that is almost unavoidable, perhaps.
Yes.
But does it not raise the problem that the Assembly is entitled to say that this report is flawed in these respects, but in truth and reality, the origin of those flaws are the rules that the very same Assembly.
Yes, that's true.
So, it's almost like, well, you can't have both your cakes and eat them. But what is your suggestion in terms of addressing that? Because you'll never have an impeachment. I mean, I might be just generalizing.
Well,
But if these
you'll have an impeachment when there is clear evidence of the offences. And
But if the panel is hamstrung in coming to the conclusion that there's such evidence, because
well, sometimes there will be such evidence.
Sure.
Sometimes the complainant will produce such evidence, and sometimes the other members of Parliament will produce such evidence. It's quite conceivable, but one has to deal with the reality of the situation as it stands. I understand and with respect accept the point that you're making, Justice Colopin, but at the end of the day, the question that is before the court is, was the Assembly entitled to say, in the light of the defects and problems in the report, whatever the cause may have been, should we refer this matter to the, rely on this, to follow the recommendation to refer this to the impeachment committee and trigger something very consequential?
And our curiosity should not extend beyond that.
That is so, Justice. Well, we can be curious, but we can't all answer all questions, Justice Colopin.
Thank you, Mr. Button.
Just one follow-up question, if I may. Mr. Button, you said yes, there might be an impeachment if there's clear evidence. My question is, clear evidence determined by whom?
By the panel.
Sorry?
By the panel. Well, first by the panel and then by the impeachment committee. But if the panel has before it clear evidence of an impeachable offence, then there will be a referral to the impeachment committee, or there should be.
Is that the test?
No, I'm speaking colloquially about clear evidence, sufficient evidence.
So what if the panel says there is sufficient evidence? Should an impeachment, should it be referred to the impeachment committee?
No, the assembly has to exercise its own judgment. It has to say, are there problems with this conclusion which the panel has reached?
See,
And secondly,
I'm just sorry to interrupt you. I'm just following up on the answer that you gave to Justice Colopin.
Yes.
Justice Colopin said that if that is the situation, there might never be an impeachment. And I just wanted to interrogate that because it seems to me there's merit in what he is saying. If we get your answer was yes, there may be, it might be referred to the impeachment committee when there's clear evidence. Now, who determines when there's clear evidence? Isn't that the nub of the problem that we're facing in this matter?
the panel makes a finding as to whether there's clear evidence, to use the colloquialism, and the assembly must consider whether it's satisfied with that. It has to apply to minds.
So-
It's not a rubber stamp.
So your answer to Justice Colopin should be adjusted. Even where there might be clear evidence,
Yes.
in the opinion of the nationalist, of the report or of the panel, in terms of these rules, doesn't follow when there is clear evidence that there will always be referral to
that
the
is so.
impeachment committee.
And that is
And
because
isn't that the difficulty with the rules?
that is the difficulty with the rules, but that's the difficulty with placing in the hands of the assembly the decision whether there should be an impeachment inquiry.
And that's why this court must exercise an oversight function to determine whether the rules that are in place comply with what this court said in EFF 2 must be done.
Certainly, the court should consider whether the rules comply with what's in EFF 2. But what EFF 2 said in passage referred to by a number of the justices this morning is that the assembly must decide whether the impeachment process should proceed. The assembly must decide whether there's a case which must be taken on impeachment. And if that's what the Constitution requires, then we are in a situation where the panel, the assembly is entitled to second guess.
And is it the submission of the party that you represent that the assembly should have an unfettered discretion in that regard?
Justice John, I don't have an instruction on that. I have my own opinions, but I don't think they'll be helpful to you. I don't have an instruction on that.
Thank you, Mr. Butler. Thank you, Chief Justice.
Mr. Butler, just two questions. Firstly, assuming we were to find that on a fair reading, the panel's report addressed itself to the right question and found that there was sufficient evidence of impeachable conduct.
Yes.
But assume also that the MPs who voted to not adopt the report did so in the genuine but mistaken belief that the independent panel had not addressed the right question. Would it follow that the vote was irrational? You've told us that rationality is an objective test. So if a vote is based on the view that the panel has not addressed the legally relevant question whereas it has, does it follow as a matter of course that the vote is irrational?
I'd like to think about that, Justice Rogers. If I can take it step by step, the Assembly, positing the Assembly forms the view that the state of affairs exists, but actually it's wrong. And is its decision then irrational?
Yes. If you wish to think about it and if the Chief Justice gives you an opportunity, unless you wish to answer it now.
I'd like to think about that, Justice Rogers.
My second question is this. Assuming the majority of the MPs in the National Assembly believed that the panel had addressed the wrong question, and assuming for the moment that perhaps the panel had got the test wrong, is it the right way for Parliament to proceed simply to reject the report? Let me give you a couple of hypothetical examples. Say that an impeachment motion alleging really serious conduct is referred to a panel, but the panel just doesn't report. It's delinquent.
Yes.
Presumably the answer would be, well, that can't be the end of it. You must then establish another panel. Here's another hypothetical example. There are 4 charges against the President that are referred to the panel, as they were here, but the panel only brings out a report on 2 of them. The answer would surely be it must go back to the panel and members give a report on those 2,
Yes.
the other 2. In this case, if the MPs thought that the panel had applied a lower standard of prima facie evidence, assuming that in the context of the report that was truly a lower standard than sufficient evidence, isn't the answer that the panel must then be required to answer the question, do they find that there was sufficient evidence? And for example, one of your criticisms, I think it is perhaps a fair criticism on the first charge, the earning of, assuming that one knows what the panel thinks on the interpretation, it takes a wide view that it includes being in a business where you are taking some decisions every now and again. Tell us why you think that rises to the level of seriousness. Speaking for myself, I quite understand the panel's thinking on charges 2 to 4. But say on that one, they say, send it back because you haven't addressed the question of seriousness. Why was it legitimate for Parliament simply to put an end to this because the panel had apparently not asked the right question? Now, I appreciate perhaps that's not the way the relief has been framed.
Yes.
It's not the way the case has been advanced, but we may need to consider what happens in this type of situation, whether it's in this specific case or the future. It seems to me completely contrary to the notion of holding the President to the account that the panel's report becomes a game of forfeits, that if you can trawl through the report and find something where it's misdirected itself, that's the end of it.
Yes. I accept that, Justice Rogers. As you say, this, of course, is not the case that was brought and the case we've come here to answer. The case we've come to answer is a case that says the decision of the Assembly was irrational. If the case had been brought saying you should refer back, ask the panel to have another shot, answer the following questions, give us the following information, that would be a very different case, and one would have to think about the facts quite carefully. But and perhaps it would be helpful in relation to future matters if the court were to indicate that the consideration by the Assembly doesn't have to be an all or nothing business. It's not either in or out. You can refer back, engage almost in a dialogue with the panel. It would be helpful to say that, and that might facilitate the resolution of future disputes about impeachment. But it doesn't arise in this case, because that's not the case which we were brought here to meet.
All right, we'll take a 10-minute comfort break until 4:30, and that will give you time to mull over.
To try and find an
his
answer
first
to
question.
Justice Rogers in 10 minutes. That's
Yeah.
very optimistic.
Sorry, what did I say? I'm looking at that.
Thank you. Thank you, Chief Justice.
10 plus 4.
It's now 4 o'clock, 10 past 4. Thank you, Chief Justice.
Stay informed. Stay connected. Welcome to News Live SA, your go-to source for the latest in South African news. From breaking news to in-depth analysis, we bring you stories that matter. Whether it's politics, culture, or community highlights, we've got you covered. Our channel is dedicated to delivering the truth with integrity and insight. Connect with us live or catch up on what you've missed. News Live SA, where every story matters. Don't just watch the news, live it. Tune in to News Live SA today. Subscribe and follow us on our social media platforms.
This is Pulse of the Week, where every story matters. From breaking news that shakes us, to the voices that inspire us, we bring you the heartbeat of our community. News that have impact, stories that spark conversations, and moments that define us. Tune in and stay ahead with the news that is not just covered, but it's captured. This is your voice, your news, your pulse. Welcome to the future of radio. VM Radio. #welcome